Hello, my dear students, my CMA final students. This video is all about CMA final law amendments June 25. I know there's a lot of information floating in. There's a lot of confusion with respect to the amendments, what I have to study, what I don't have to study. So I'm just here to clear the air. Although I have with me a PDF, a friendly, user friendly PDF designed for you, a short, crisp PDF designed for you, which I will be sharing. My sincere request and a disclaimer to everyone is that please don't take the PDF and just try to read it on your own. Okay, this is there, this is there. It might add up to your confusion. So there are many things which I want to clarify, which I want to tell you, which you must know as a professional, and thereafter you can make an informed choice. You can understand the amendments, you can know what to do, what not to do. So I will be really quick in this particular video, but you have to watch the video till the end. Don't skip this queue, right? This is the protocol which has to be followed. Now, the first thing that I want to tell everyone is that don't unnecessarily stretch the file and your mind with information you don't need. Okay, so first thing, if I begin with, so here I have this amendment. So I have this like chapter's name is there, the topic, the old amendment, the new amendment, and should you study or should you not study, or remarks, etc. Whatever I want to tell you, right? So the first thing, when I say Companies Act, there might be a lot of things which you might be seeing that, okay, small companies limit has been amended to 4 crore, 40 crore. Okay, OPC now it can be like a resident or a non-resident. Well, cut the crap. These amendments are like years old, right? So treating them as amendments, oh my God, there's a huge list of amendments. No, there aren't any amendments in Companies Act which you have to study. Okay, the same goes for IBC. In IBC, you might be seeing that, okay, the limit has been changed from like 1 lakh to 1 crore, like it was done back in 2020, right? PPIRP, persons entitled to initiate CIRP, it is all something that you didn't even know the old law. I would say that, right? Unless you have been studying from like 5-6 years, studying the same thing, right? So this is something that you know new only. Why name it as amendment? It's not an amendment. Amendment means amendment or the changes which you come across from the last attempt to this attempt, right? Which has been made relevant or made applicable for you. Now, because you are CMA final students and not CA final students, why am I saying this? Because it's very important to note the difference. You are studying for two purposes. Purpose number one is to clear the exams, and purpose number two is to become a good professional. So when I'm talking about becoming a good professional in the classes, even in the last attempt, I have told you while taking the classes, I've told you a lot of things with respect to like this lock-in, etc., etc., right? This 100% of proceeds, etc., etc. I have told you this long before, that these are the changes which have come, but you are not supposed to read it. Why? Because you also want to score marks in your examination. Okay, moving to the next topic. Moving to the next topic, right? I will come to Sebi regulations, which has a lot of changes and which is creating a lot of confusion also amongst the students. So these are all the changes that I have written. These are also not the changes in entirety. Let me tell you, there are more to it, right? But these are the important ones which you come across and which are there, right? And what should we do with respect to these changes? So let me tell you, first of all, these SEBI regulations have not been amended recently. That, okay, SEBI ICDR regulations have been amended just 7 months back and now this is an amendment and I have to read it. No. Some changes of 2021, some changes of 22, and institute's new syllabus was introduced in June 23, right? From that it became applicable. In fact, the latest edition is a lot more new. But institute has not incorporated these changes. Point number one. Institute in its supplementary has never said, like even if you look at the June 25 supplementary in SEBI ICDR regulations, it's written no changes. In SEBI regulations, some changes are mentioned that, okay, check SEBI website, but those changes are not relevant to us. Okay. If I look at, there was a student bulletin, I think in August 23. I'm not very sure about it, but definitely there was a student bulletin in August 23, I believe. There also, they have mentioned the old limits, they have mentioned the old provisions only. And Institute for all these years in their publications, in their practice questions, in everything, they have always been writing the old questions, the old answers. So even if you know the new answers, there are probably very, very, very less chances. Like if I ask you, minimum promoters contribution has to be logged in for a period of, and I give you four options, and the four options says 3 years, 2 years, 1 year, 4 year. What will you do? You do not have the option of 18 months. What will you do? You have to write 3 years, right? Okay, so one by one I am going to tell you a few things and how your approach should be. Okay, so when I talk about Sebi ICDR regulations, we have minimum promoters contribution, right? When we are talking about public issue, we have minimum promoters contribution. It is logged in for a period of 3 years, and in excess of minimum contribution, the contribution which the promoters have made is logged in for a period of 1 year. This has been reduced to 18 months and 6 months, but of course it is not included anywhere. So I would still tell you that you revise this only, but have this in your subconscious mind, and if specifically a question is coming, you may additionally write at the end note that this promoter's contribution limit has been revised to 18 months or 6 months, as the case may be. Again, if there is a case where majority of the issue proceeds are going to be used for capital expenditure, the lock-in shall remain to be 3 years only. Fine. Is that clear? Okay. Now, we have also read something about eligibility of issuer, which is a very common question asked, right? That if you want to go for IPO, are you eligible to become an issuer or not, right? So, who is going to be eligible to become an issuer? One of the points in that is that the promoter or the director should not be a willful defaulter. Willful defaulter, I told you, as we have like Vijay Mallya, somebody who has money but doesn't repay it, right? Somebody who runs into insolvency cannot repay it. So that particular person is not a willful defaulter. Okay. Now there has been a slight addition that an issuer can't make public issue if he or any promoter or director is a willful defaulter or fraudulent buyer. Again, I would say the amendment is not material. I mean, if you're writing a point till here in your question, I guarantee you are going to get full marks. Okay. If you have written all the points as are needed. Okay. Now, there is another thing in that only in eligibility of issuer, that if minimum subscription has to be received, right? Minimum subscription of 90% has to be received, then only you can proceed with the IPO. If it is not received, it has to be refunded within 15 days of closure. Now, the new limit is within 4 days of closure. It's written with, please make it within 4 days of closure. So earlier it was 15 days, now it's 4 days. Again, I'm telling you the amendments, but at the same time, I'm also telling you that why I didn't tell you the amendments, or why I'm still urging and saying that you cannot forget this. Because Institute, from years, from attempts, they have been doing this only, and they have been judging you for this knowledge only, which may be correct, which may not be correct. We're not here to comment, we're not here to complain, we're only here to make a smart move, right? Okay. Now, I in my last not in my last live session, but I would say in the last live session where I was discussing the questions, I told you this, that now the monitoring, I think I told you this 5 months back only, right? I told you this, that now we have raised IPO. How are we utilizing the proceeds of IPO? That is was being monitored by the banks or PFI till our 95% of the proceeds were utilized. Now the monitoring is going to be done by the credit rating agencies till 100% of the proceeds are utilized. Okay, so again, a slight amendment is there. Why am I telling you, or what you have to do? Again, I will repeat that these all the amendments relating to SEBI regulations, you just have to keep in mind. You just have to keep in mind. Okay. There is something called as SEBI PIT regulations also, wherein we talk about the trading plan. What is that trading plan we're talking about? We all know that the insiders can do trading, right? When can they do trading? When they are not in possession of UPSI, that is unpublished price sensitive information. How can they do it? They have to formulate a trading plan, present it to the compliance officer. Compliance officer goes through it, approves it, and it has to be there for public disclosure. That means it will be disclosed in the public domain, so that public, there is complete transparency, and public also gets to know, okay, these insiders are planning this, right? So your trading plan is going to have all the planned transactions. These are the types of securities, the quantity, price range, everything, timing, etc, etc. So there is a complete plan which is there at public disclosure. Now, of course, there's a period that when can you begin the trading, right? So you cannot begin trading earlier than 6 months from the disclosure of plan. So here you have disclosed the plan 6 months. After 6 months, your trading could actually happen. This was the earlier thing. Now it's 120 days. So this has been reduced. This has been reduced. Okay. Now, we talk something about book building. We all know about book building, right? Now, we also know that we have been given the allocation, net allocation, like we have, that is what we have to read in the book building process. There we don't read anything else, right? So we have like book building. If you satisfy the criteria, then what is going to be the allocation? If you don't satisfy the criteria, what is going to be the allocation? And then comes the case, if it is an issue other than through book building. Minimum 30% was required to be offered to retail individual investors. Now it's 50%. Again, I would say there are a lot more amendments, but prima facie, I'm highlighting the ones which are directly and clearly connected and has that limits. Okay, so that somehow becomes more important. Okay, because also there is some insertion of 3A, but I'm not dealing with this right now, which talks about the allocation of non-institutional investors category. Forget all that, right? So forget all that. These things you should keep in mind. That is promoters lock-in period 18 months and 6 months. Minimum subscription to be refunded within 4 days. Monitoring till 100% proceeds are utilized. Trading plan not commenced earlier than 120 days, and issue other than through book building, retail investors 50%. So these are the points which you are not going to write, but you have to keep in mind. Is that clear? Okay. Now, we come to I have left this IT Act right now. I'll tell you that later. Now we come to Competition Act. Again, Competition Act is something which has been changed drastically. And I have told you this before also. Now, what should we do? What should we not do? If I go on to tell you all the amendments in Competition Act, although all have not been notified yet, the notification or effectiveness is like Companies Act. Companies Act also was notified in a phased manner, and so is like Competition Act also. So basically, some sections have been notified, some are yet to be notified. This is how it's happening, right? So there are many amendments which have been effective from 10 September, like amendment in section 6, 7, 8, 21, 22, 23, 24. There are more, right? So what should we do, ma'am? Again, if you open institute supplementary, it's clearly written no change under Competition Act. So how do I tell you that instead of this 210 days, you read 150 days and write an examination? You might get a big zero, and you will be like, we are ultimately, right now our focus is to secure marks, and we're not getting marks for that. right? So it is not expected, and it might also create confusion. So the best solution would be, if it is asked in MCQ and there is an option of 150 days, you can take the risk of taking this, right? If it is asked in a descriptive question, it is always advisable to write and add a note that this has been revised to 150 days. Okay. Okay. There are high chances that probably, even if asked in MCQ, they will write 210 days only, because in this supplementary they have clearly not incorporated the changes of Competition Act. There are three things that I want to tell you, okay, under Competition Act. One is this one. What is this? When we make an application to CCI for approval of combination, if we don't get any reply, it is deemed to be approved if there is no reply within 210 days, which has been reduced to 150 days now. Okay. Secondly, you have to give notice to CCI within 30 days of approval of proposal by the board, right? So of passing of resolution, within 30 days you make a notice to CCI. Now this 30 days has been removed. You give notice after approval, but before consummation of combination. So before that you have to give. Okay. There are many more changes, but these are the two prima facie changes which I want you to just keep in mind and remember. Okay. Now, combination limit. There is also confusion floating with respect to combination limit. So this is the combination limit or the threshold limit which you should keep in mind. Ma'am, we have read a previous limit. What do we do now? Because that limit only exists in the institute's material, etc., etc. For the combination limit, it's my sincere advice that please, please, please write the new limit also. Okay. So if you do not know, just remember prima facie these four things. Okay. And of course, ideally, you should be learning the entire thing. But now, in examination, ma'am, if a question comes with respect to combination, what should we write? I would again say that go ahead and write what you have read, right? But at the end, see, I have written here also, it is advisable to write both if asked in descriptive questions by adding a note. So the new combination limit should also be written clearly in the examination. That is what my suggestion is. Okay. That is what my suggestion is. Now, Surfacy Act. Some of the students have been asking me, ma'am, that ARC, what is the owned funds that they have to maintain? Well, let me tell you, there is no amendment in Surfacy Act. When you look at what institute teaches us, it is always that these are the owned funds that have to be maintained, like 2 crores or higher as may be specified by RBI. Now, RBI through their master directions earlier also specified 100 crores. Like then they made a master direction and they said that you have to increase it in phased manner. Like by 2024 it should be 200 crores. Then by 2026 it should be 300 crores. So it is not that you strike off that 2 crores and then that is 300 crores. No. So, prima facie, just keep in mind no change in Surfacy Act, no limit has been changed. Currently, the requirement, as according to RBI master direction, is that the asset reconstruction companies should have an owned funds of 300 crores. That is the requirement, but that has not been, like, there's no amendment as such. Fine. Okay, now we come to the MSME limit. Now, MSME limit has also been changed, but that's not applicable for your June 25 attempt. Okay, so the limit that was last changed in 2020, right? So, this is what you have to remember. Okay, this is what you have been reading. I don't think there's any change or in which you like the same thing you were reading, right? Okay, and the new limit is not going to be applicable to you for your June 25 attempt. Okay, now there is one small change which I actually believe that yes, because it's a new amendment of August 2023, and I believe that you should know this, is in IT Act There is section 72A, and earlier there was a punishment, and now there's penalty for disclosure of information and breach of lawful contract. That means the organizations, we see that they take a lot of information and they're not supposed to disclose it, but if they breach it and they disclose it, then there was a fine of maximum 5 lakhs and or imprisonment of maximum 3 lakhs. Now there is a penalty of maximum 25 lakhs, so penalty which may extend to 25 lakhs. Again, ma'am, if asked an examination, what should I write? I would advise that write both. Okay. So if I conclude this particular video, there is no amendment which has been notified by the institute that this is the amendment that you should study for your examination. Okay, so we can say that prima facie there is no amendment which is relevant for your upcoming June 25 examination. Having said that, as a responsible professional, as a responsible student, what you should keep in mind is these 4 or 5 things of Sebi regulations which I told you. This one thing of IIT Act, these 2 things of competition, and that's it. Okay, so this is what you keep in mind, but you have to act responsibly. I have not made the paper, so I cannot tell you what to do. There will be a slight professional judgment involved in the paper, that when you appear for the paper, you are like, okay, this is the question, what should I do? So make a professional and wise decision. If there are descriptive questions and you know both old and new things, then of course write both. Write the old one, and at the end you can always add a note and highlight that you know this, right? And I would never advise that remember only the new ones and forget the old ones. I cannot tell you this. Okay, so you have to, like, usually when the amendment comes, I am always like, okay, now forget this. This is what you have to read, right? But I cannot tell you this right now because the institute has not notified any of the amendments in their supplementary or in their study material or in their any of the publications. Okay, and apart from that, forget about the old amendments, everything. Don't take a lot of load, just revise well what you have done. Keep in mind these are the very few things, like 6 7 small points that I have told you, right? And I have explained you, this will somewhere be in the back of your mind for the next 2 3 days, of course. Okay, so wish you all the very best. Skill, in case you have any doubt, always welcome through the comments. I'll try to answer as much as I can. Thank you.